famous cases, and he is a hard worker. He spends enough time for preparation of his cases. It's very difficult to get his time. We have been persistently following him, and after such a long wait today for the exam goers, he is present with us today. And it is indeed a great honor that he has joined us today. And this is part one. He'll be taking us through the series. Welcome, sir. One kind request to all the participants, kindly switch off your videos and just have only the listening part, and videos, kindly don't open your videos. Sir, you can start the session, sir. You are a co-host now. You can start sharing your screen, sir.
Thank you so much, madam. A warm good evening to all, one and all who are present here. I am delighted to present the subject again, and it is my one of the very favorite subject, I can say, and I hope that I'll be rendering my best the lecture to make you to understand the overall concept and framework of the Evidence Act. And first we will start with, before going into Evidence Act, we will start with the Oath Act. What is our obligation when being a witness? What is our obligation under the Oath Act to whenever we are deposing before the court of law? So this Oath Act, it's a very small act. Earlier it was Oath Act of 1873, which came about when our High Court was formed. 1861 High Court was established, and after that 1873 this old act has been repealed in 1969, and the new act has come into place, but almost all the provisions of this old acts have been reincorporated here, and which is now being used. Before dwelling into the Evidence Act, why it is important is that certain obligation that's been attached with the Oath Act on the witnesses. The Oath Act, Section 7 stipulates if there is any omission in the oath, or if there is any irregularity in the oath, that will not invalidate any proceedings or render inadmissible any evidence. I will read that entire provisions of this 7. You have to understand, because we are obligated under Section 7 and Section 8 first. First, what is the procedure that is stipulated in 7 is the proceedings and the evidence not invalidated by omission of the oath or irregularity. No omission to take any oath, or make any affirmation, no substitution of anyone for any other of them, and no irregularity whatever in the administration of the oath or affirmation or in the form of which it is administered shall invalidate any proceedings or render inadmissible any evidence. Simply saying that words will be very jugglery and complicated. Simple understanding is an omission in the oath, omission to give the oath, or any irregularity in giving the oath will not invalidate the entire proceedings in which the recording of the evidence had been taken, or it will not also render inadmissible any evidence that's been adduced by a witness. So what it means, any omission in the oath will make even if there is any omission in the oath, it will make the evidence admissible. Then it will go to the credibility, where the question of on credibility we have to test as, because the oath has not been administered, whether it is credible or not, believable or not, reliable or not. That question will come in the later point of time. For the admissibility purpose, this will not render as because the oath has not been administered by the court. This is the number one section that you have to understand and you have to keep it in your mind. And then we will come to the Section 8, which is very important, which says that any person giving a oath before the court, any person who is giving a oath before the court are bound to state the truth on the subject. Bound to state the truth on the subject. You see this? I'll go through the entire section, what is stipulated here. Marginal heading would be person giving evidence bound to state the truth, which we never, this also I came to my knowledge very recently. and this I have read it in a judgment called Rameshwar versus State of Rajasthan, that is in 1952, AARSC 54. Please, you can please note it down. It's a very important key judgment for appreciation of the evidence, and the child witness is being appreciated, and child witness, whether it could be relied or not, being oath not being administered. That was a prime question that was dealt with. Apart from that, other questions were dealt with, but I found it one of the wonderful judgment which was written by in 1952 by Justice Vivian Bose. And this section 8 says, every person giving evidence on any subject before any court, person hereby authorized to administer the oath or affirmation shall be bound to state the truth of such subject. So you will simply saying, every person giving evidence on any subject before the court shall be bound to state the truth on the subject. This is what it states. So section 8 makes it mandate on each and every person who is giving evidence before the court to state the truth on the subject is the key word here, which we'll have to bear it in our mind, that every person who is giving evidence, there is risk of repetition, I am saying, every person who is giving oath before the court, giving evidence before the court, shall give the truth of the subject. This is the mandate that's been imposed on us by the law. It's not simply like that you can go and say something before the court and come out of the court. And this, we are duty bound, we are bound over by this law, and we have to abide by the law, and in accordance with these provisions of this law only, we are supposed to get the vote, and we are supposed to say the truth alone. Therefore, any untruthful statement are liable to be perjury. This is how the perjury comes. Then the second important provision which you will have to bear it in mind in Oath Act is concerned, section 4 of the Oath Act. As far as section 4 of the Oath Act is concerned, for this also you please go and read the judgment Rameshwar versus State of Rajasthan, that was decided in 1954, AARSC 1954 at page number 54. This in this judgment it has been very clearly said that section 4, as per the proviso to section 4, a child up to the age of 12 years need not be administered with the oath. The child up to the age of 12 years need not be administered with the oath at all. She may not be able to understand the nature of the oath. By means of the oath, what is bound over on her or him, a child of 12 years, below 12 years old. If she is able to understand what is the nature of the oath, and if she is able to understand what is his duty to bound to speak the truth, bound and duty to speak the truth, then the oath could be administered. Otherwise, if she is not able to understand the real nature of the oath, what is the purpose of oath, and by means of the oath what is being administered, and how should I behave in the court, and how should I react in the court, what is my duty towards the court, these are the things which she has to understand on the basis of the nature of the oath. So if she is not able to understand, as far as this Rameshwar's case is concerned, the girl of 12 years, of less than 12 years old, therefore whether she is capable of understanding the nature of the oath or not is the primary question that was involved. Even if the nature they have not understood the nature of the oath, if she is able to understand her duty to speak the truth in the court, if she is able to understand she has to speak the truth in the court, then the oath need not be administered and she could be exempted from administration. This Rameshwar case is a case of child rape, and the victim would have been raped by the accused, and she will immediately after the rape, she will come to the house and she will say to some about 4 years of gap will be there, and she will disclose that what has happened, what accusers did for her, that was disclosed to the mother, and mother will go and file a complaint, and this is how the case will come out. The question that was involved is the statement that was given by the girl to the mother, whether it is a statement that has been which will fall under section 157 of the Evidence Act, which is a statement which is coming under at or about the time when the incident has happened, or whether it corroborates the testimony of the mother when she deposed before the court, testimony of the girl which deposed before the court, as well as there are two things. After this, once the trial has been started, the testimony of the girl also will be there in the court, the testimony of the mother also will be there in the court. Now, the girl will say, I immediately after the incident, immediately after my mother arrived my house, I disclosed what has happened to my mother. The mother also will say, my girl immediately, I went into the house, I went from the field, I came to the house, I just entered in the house, she started weeping, she told me everything that the accuser subjected her to rape. So these are the two statements which are available. Now, the statement of the testimony that is being given by the girl is being corroborated by the testimony that's been given by the mother. Okay, please be clear. I'll come to the what is substantive and corroborative. That's the next important thing. Now we are in the Words Act. We have not got into this Evidence Act. So here, the testimony of the girl. This is a previous statement. This we can take it as a former statement which is falling under section 157 of the Evidence Act. 167 of the Evidence Act says that the former statement could be used to corroborate the later testimony as to the same fact. The later testimony as to the same fact. What is the later testimony as to the same fact? My girl came and deposed. My girl came and said me that she has been raped. At the same time, the victim also will come and say, I was raped, Mama, I was raped by so and so. This also could be the statement. So these two things are the subsequent statement, later testimony as to the same fact before the court of law. So whether this needs to be corroborated, these two statements which are deposed now pertaining to the earlier former statement, now being deposed before the court as a later statement as to the same fact. Same fact means what? I said a statement to my mother that I have been raped. This is the former statement. This is a former statement. Later testimony is the testimony that's being deposed before the court. Please understand the difference between that. I think that I have made myself clear. If you are not clear, then I will take this topic in while we are dealing with the 157 Evidence Act. And this former statement of the girl telling to the mother will tend to corroborate two substantive pieces of evidence which are before the court. One is the girl deposing before the court saying that immediately after the occurrence I went and said before the court, it's not deposition, went and said to my mother that I have been raped. And also the mother also will say immediately after I enter into the house, my daughter, she came and said that she has been raped. I immediately preferred a complaint. These are the former statement. The child statement is a former statement which will tend to corroborate the later testimony as to the same fact, which will fall under section 157 of the Evidence Act. So now you have understood this. I presume that you have understood this Oath Act, section 4, section 7 and section 8. All these three things. Section 8 says any irregularity or omission, not giving an omission in the administration of the oath will not render the evidence inadmissible, and also it will not invalidate the proceedings, invalidate the proceeding that's been conducted. These are the two things, outcome of this. Two outcomes are there in the section 8. Just please go through that. And we will come to the section 8 of it. A person who is giving a deposition before the court are bound to say the truth of the subject. These are the two mandates. This is a mandate which is given on the witnesses once they are getting into the box and deposing about the subject issue. These are the two things. Section 4 gives an exemption to the whether all the persons, 118 of the Evidence Act will say that all the persons are competent to give evidence. All the persons are competent to give the evidence unless they are prevented from understanding the question and to give a rational answer. If they are prevented from understanding the question and to give a rational answer by the reason of tender age, by the reason of extreme oldness, by the reason of body disease of any of the kind, if these are the things which prevented you from understanding the question, then you become incompetent as far as section 118 is concerned. For the child up to the age of 12 years, whenever you read 118, you have to read it in conjointly with the section 4 of the Oath Act. That's what the Oath Act prescribes. The child up to the age of 12 years may not be able to understand what is the nature of the oath, may not be able to understand her bounden duty to say the truth before the court. Therefore, she would be exempted. Before that, their test would be conducted. A test of simply a questionnaire or answer will be asked from the judge. Judges, to arrive at an opinion, they have to form a report as to the rationality of the answer. She could understand where she is, what is her responsibility before the court. She has understand what is her what is the purpose for which she has come, and she has understand her duty to depose the truth before the court of law. These are some rational opinion that has to be formed by this is desirable. That's what the judgment Rameshwar versus Rajan says. It is desirable for the judge to form an opinion as to the rationality of the child witness. So therefore you have to understand we have to read Section 118 of the Evidence Act, which stipulates about the competency of the evidence, along with the Section 4 of the Oaths Act. This is how the Oaths Act, the simple prefix of it's a preface, which before I am getting into the Evidence Act, what is the importance of the Oath Act, how the Oath Act is connected with the Evidence Act, which I have narrated. So therefore you have to bear it in your mind always, that whenever you are going for a deposition or to cross-examine or to chief examine or to cross-examine, you have to bear it in your mind, this mandate that's been provided by the Oath Act. Now we will come to our favorite area, the topic that's been given. It's the Evidence Act and the part 1. And I think that for the time available, we can go up to oral and documentary evidence, I think. Before getting into the Evidence Act, you just go around that overall subject, the headings that's been given, how the chapters are being divided, and how the chapters are being dealt with in the evidence. What is the overall framework of the Evidence Act? And for the purpose of the examination also, you have to note down all those things. First, we will have to see the chapter number 1 is pertaining to the interpretation clause. Interpretation clause as to the section 3 and section 4 will be in the interpretation clause. Section 3 is most important, which you have to understand about 8 or 9 concepts which are given in the section 3, like fact in issue, relevant fact, document, evidence, and what is proved, disproved, not proved, and all. We will come to that topic. And chapter 2 deals with the relevancy of the fact. What are the facts which are relevant? Why it has been stated as relevant? What is the need for it? What is the consequences of the irrelevant fact? Whether we can see that irrelevant fact or not, whether we can admit the irrelevant fact in the court of law, before the judge's table, whether judge can look into the judge can have a vision over the irrelevant fact or not. Then comes the chapter number 3 is the facts which need not be proved, like judicially noticeable facts which had been admitted. What are the facts in which the court has to take a judicial notice? This is coming under the chapter number 3. Chapter number 4 is oral evidence, which we must be knowing about it, and we will go in detail. We will go and see that. And chapter number 5 is the documentary evidence. Chapter number 6 is exclusion of oral by documentary evidence, which starts from section 91 to section 100. Then burden of proof, that is chapter number 7. Chapter number 8 is estoppel. Chapter number 9 is witness. Who are all the witnesses? Which already I have said 119 to 134. No number of witnesses is required for the purpose of proving a particular single fact. For proving a single fact, it is not required number of witnesses. A single witness with a good quality is enough. Reliable quality is enough, which we will go into the details. We will go through the judgments pertaining to that also. This is chapter number 9. What is chapter number 10 is most important is that examination of the witness, where you will have to chief examine, cross-examine. You will have to deal with the previous statement, former statement, what is previous statement, what is former statement, what is leading question, what is proper question, what is improper question. All these things which you will have to understand under the chapter number 10. This is a broad outlook of the Indian Evidence Act. It contains about 10 chapters. I already narrated the 10 chapters, which we can very simply go through the index and get it in our mind. So this is pertaining to the overall framework. Now getting into the Evidence Act, we will have to first see what is why Evidence Act, what is the purpose which we will have to it has to be enacted? What is the purpose for which it has to be enacted? We can always see something, we can always hear something, which we can always see somebody is attacking somebody, we can always see some commission of the offense. For proving that before out of court is concerned, the procedure adopted is totally different. For proving that inside the court of law is concerned, to make the law, to use the judicial eye, to make use of it, and to apply the judicial mind whether it has happened or not, whether it is a real thing that has been projected by the police or not, these are prosecution or not, these are the things which required to be proved. These are the things which are required to be proved before the court of law. For the things which are required to be proved before the court of law, we require that Evidence Act to make the normal evidence as a legal evidence. Then what is normal evidence? I am not saying the evidence that is coming under falling under Evidence Act. I am saying the normal evidence is ஒரு சாட்சியம் இருக்கா, உங்கள்கிட்ட என்ன அத்தாட்சி இருக்குது, உங்கள்கிட்ட என்ன ப்ரூஃப் இருக்குது, அப்படி என்ன நிச்சயங்கிறீங்க, என்ன சர்டனிட்டி இருக்குது அப்படின்னு நம்ம வந்து கொலைக்கியலாக நம்ம கேட்கலாம். இட்ஸ் அ கொலைக்கியல் லாங்குவேஜ். பட் வென் எவர் வி கோ டு த கோர்ட் and I am sitting as a judge, I cannot simply ask, so you get the document, yeah, you have a document, I will accept it, right, you have a document. So you are saying that he has kicked him, yeah, I will accept it. It's not the case. It is having some sanctity before the court of law. The court is having some sanctity. Only subject to the sanctity you are leading the evidences. The evidences could be termed as three types, that is of oral evidence, documentary evidence, and electronic evidence. These are the material evidence that could be. Apart from the evidence, the court is having its inherent power, like something superior power, where out of the proved fact they can presume a new fact. From out of the proved fact they can presume what has happened. That is an extraordinary power given to the judges under section 114 of the Evidence Act, as well as on the definition of which is given in the section 4 of the Evidence Act, which we will go into that in detail. This is for the general understanding. So these are the broad classification where we can say evidence can be as evidence, oral evidence, documentary evidence, and electronic evidence. It could be given, and it could be also a fact also could be proved. A legal proof could be obtained by means of a presumption also. So there are two methods. One is by evidence, one is by presumption. Evidence could be divided into oral, evidence could be divided into document, evidence could also be divided into electronic evidence. Now it's a recent concept, recent development, that so many developments that has come in the electronic evidence, and one another is a presumption. These are the totally four ways. We can say oral, document, and electronic document, and the presumption. These are the four ways in which the proof could be proved before the court of law, which is what is required by the court. We want a legal proof. It is not the proof that what the police is having. It is not the proof that you and we are having, the defense advocate is having, and the prosecution advocate is having. But that proof, that material that's been collected by the prosecution, by the investigation officer, it has to be converted into evidence before the court of law, for which purpose the entire Evidence Act being enacted. So unless otherwise you subject the materials which you have, subject it to the Indian Evidence Act and put it before the court of law, you will not be able to prove the fact at all in your hand. If you have a fact in your hand, you have to put it in the Evidence Act, and in accordance with the Evidence Act, in accordance with the provisions of the Evidence Act, it has to be taken before the court and it should be shown before the court, and then the court will get the vision to see it only if it is in accordance with the Evidence Act. Otherwise, the court will not see that. Court will say it is not in accordance with the Evidence Act, so I will not say that. It is not at all legal evidence, on the basis of which I cannot give you any adjudication of the issue. It is not a conviction, adjudication of the issue. Either it may land up in conviction or it may land up in acquittal. So this is the purpose for which the Indian Evidence Act is being used. Now we will come to section 5 of the Evidence Act first. Why section 5 of that? Section 5 of the Evidence Act says? So we have understood about the evidence. The material is collected by the investigation officer. If that material is, when going to the court, and subjected to under the provisions of the Evidence Act, it becomes an evidence. Suppose, say for example, if it is a oral evidence, a deposition, a 161 statement has been recorded by the police officer. It's a 161 statement, not to be signed, that witness would have said it or he would not have said it, whatever it is. But when that witness comes to the court of law, that witness has to get into the box. The witness has to be administered with the oath that whatever I am saying is only truth, not beyond truth, and it's only truth. Therefore, the Oath Act, I narrated about the Oath Act earlier. So, now she will understand, because of the Oath Act, because of the oath that's been administered, I am bound and duty to give the truth alone. And when the court permits the statement and court requires the statement to be permitted, or it under section 3 of the Evidence Act, it requires or gives a permission for the statement to be recorded before the court, then it becomes a oral evidence. It requires the witness to make a statement or gives permission for the witness to make a statement. There are two definitions that's been given in the oral evidence. We will go into that. This, for example, I am saying. Then we will come to section 3 of the Evidence Act, which gives a definitions class for lot of words that are what we are going to use in daily life. So we have about 8 important definitions which you will have to keep it in your mind. Number 1 is the fact. Number 2 is the fact in issue. Number 3 is the relevant fact. Number 4 is the document. Number 5 is the evidence. Number 6 is the proved. Number 7 is the disproved. Number 8 is the not proved. What we have read in the law college, we would have tend to forget it because of our practical experience, or may not have seen that, but we have been doing the same thing in the court. But what actually theoretically written in that will tend to go out of our mind because of our heavy schedule and hectic schedule. That we have to again and again we have to recollect, and we have to keep it in our mind. So before getting into this class 3 of the Indian Evidence Act, you have to understand there are 5 important tests for the Indian Evidence Act. What are the 5 important tests? Why should be a test? First one is, only certain things could be admitted in the court, not everything. If you have so many things, we want only the relevant fact. Court will say you lead evidence only on the evidence fact, only on the fact in issue or relevant fact. You adduce evidence only on the relevant fact. That is the number 1. That relevant fact is defined in section 6 to 5 to 55. 5 is the mandatory section which we will have to explain about it. That's all the way we have crossed the subject. We have just deviated from the subject. And section 5 is very important, but the relevancy starts from 5 to 55 of the Evidence Act. So if the evidence is going to fall under section 5 to 55 of the Evidence Act, then it would become an relevant fact. Only if it is a relevant, then it becomes an admissible fact. Otherwise, it is not an admissible fact. Once it is a irrelevant fact. So mandatorily, it should be a relevant fact to get it admitted. That is the first 2 tests. Relevancy is the first test. Second test is admissibility. Whether this fact is admissible or not, whether this fact is admissible or not, whether this fact is admissible or not is the very frequent questions which we tend to use in the court daily. Other 3 tests are there. Right. We will accept that this is falling under relevancy. What are the section under the 5 to 55? Assume that it's a dying declaration under section 32 of the Evidence Act. So now it is admissible evidence. Now it is falling under the realm of 5 to 55, therefore it is a relevant fact. Having been a relevant fact, it is now an admissible fact. So first 2 things are now satisfied. First one is relevancy, right? Then is admissible. Then 2 things have been complied with. What is the third thing? Simply because admitted, is the court can go for the conviction. Is it well founded? Is the conviction could be well founded on the basis of the admission of the facts? There comes the touchstone test. That's called touchstone test, called the test of reliability, the test of credibility, and the test of inspiring confidence. That comes. All are same. I put all the three, only one question, one test number 3 that is. One is reliability, one is credibility, one is inspiring confidence. We can also take this as a believability. These are the 3 things which we'll have to take into consideration. If the reliability is there, credibility is also there, believability is also there, inspires confidence also is there. But to what extent? It inspires confidence. Whether that inspires confidence is sufficient to affect conviction or not. Therefore, we will have to see other 2 tests called, one is weightage, other one is sufficiency. What is the weight that could be given, whether this weight is correct weight or not, whether on the basis of the weight, whether I can accept the material or not, and sufficient, whether it is sufficient to affect the conviction. Well-founded conviction could be given on the basis of the sufficiency of the evidence. If it is not sufficient to convict, then what will happen? The case will go on the benefit of doubt. There are something available, but this is not available to the extent of convicting him. Something is available. That something is available will give only the benefit of doubt. This suspicion alone will arise. This suspicion will not take the place of proof, legal proof. The suspicion, the surmises, the conjectures will not replace the place of proof. I want legal proof with sufficiency to convict a person. This is what the 5 important tests. Before getting into the subject, I just wanted to narrate these things. Okay. The another important thing I want to narrate is I have not come into this section 5 at all. That's all of the sudden I have deviated from that. I will come to the section 5 at all. Before that, you please understand this also. That is, what is a corroborative piece of evidence? What is a substantive piece of evidence? That is also more important. So, substantive piece of evidence, it's almost like a pillar in the building. Without this pillar, the building cannot stand at all. This pillar is must and mandate for the purpose of making the building to stand. So this is a substantive piece. Then what is a substantive piece? With respect to the fact in issue, whether A attacked B on the chest and on the head. These are the 2 things which caused the death. Now there is an evidence A attacked on head and subsequently A attacked on chest also. If these are the 2 things which could be taken for the purpose of proving the fact in issue. Fact in issue is what? Whether A attacked B, number 1. First primary issue will be fact in issue, A attacked B or not, number 1. Number 2 is, there are 2 medical injuries. One is on head, one is on chest. Right? And whether A is an accused, whether C is a witness who deposed correctly, A attacked on head and A attacked on chest. If the C comes and deposed before the court as to the fact in issue, these are the question as to the fact in issue. What is an issue? A killed or B is the issue. What are the facts involved in that? Whether A come to the house of B, whether A had a knife in his hand, whether A hit on the head, whether A hit on the chest. There were 2 injuries available in the postmortem report. The 2 injuries had been deposed before the court of law by the expert evidence. So will it not, this ocular evidence will coincide with the medical evidence? Will it not tally and coincide with the testimony that is given by the C? C says before the court, yes, A came to the house of B. I was also standing there. He took a knife from his hand. He had a hit on his. He hit the B on his head. He hit the B on chest also. So all these things, when it comes before the court, on box, on oath, on affirmation, this all will become substantive piece of evidence. It becomes a substantive piece of evidence. Assuming that C himself has given the first information report. Similar facts had been stated in the first information report. Then the first information report will become a formal statement which will fall under section 157 of the Evidence Act, and this former statement will tend to corroborate the later testimony as to the same fact. So the later testimony to the same fact, C deposing before the court will become a substantive piece of evidence. C being an informant and author of the FIR, and its contents in the FIR will tend to corroborate the substantive piece of evidence given before the court. So FIR is a corroborative piece which could be used for the purpose of corroboration and also for the contradiction under section 145 of the Evidence Act. And this will tend to corroborate what? It will tend to corroborate what is his testimony before the court of law as to the content, as to the fact and issue. These are the two things that we'll have to keep it in our mind for purpose of understanding the corroborative piece of evidence and substantive piece of evidence. So we have said the substantive piece of evidence will be like this. And there are other corroborative pieces of evidence which are narrated by the statutes itself. Statute says the former statement made at or about the time when the incident has happened, that is a former statement. The statement which had been given to the legal authority at the time of legal authority who is competent to investigate into the matter. These are also a former statement. These two statements are falling under section 157. Apart from that, one another statement, the statement which is given to the statement of the witness, which is given to the magistrate under section 164 of the Evidence Act. That is also a statement which is a former statement, and this is also falling under the 154 of the Evidence Act. These are the statement. Apart from that, the previous statement in writing which are falling under section 145 of the Evidence Act are also corroborative piece of evidence which will tend to corroborate what is deposed before the court of law. These are all the pieces of corroborative piece of evidence which I can narrate. That apart, there are certain judge-made laws which says that for certain things the corroboration is required. That too, when it does not inspire the confidence of the court, like child witness, it requires a corroboration. Why? Because as a matter of prudence, because as a matter of caution, we say that child could be, because the child could be tutored, child could be influenced, and it requires some corroboration from the independent sources. Otherwise, there is no bar at all. If it certainly inspires the confidence of the court, absolutely not bar at all. That's what the Rameshwar case says. Rameshwar case says, in certain cases, save the class of corroboration. Corroboration is not at all required. The girl is completely inspirable, and she acquires my confidence. She takes away my confidence. She gets my confidence. So therefore, it is absolutely not required to be corroborated. If we corroborate it, we will tend to doubt the piece of evidence. That piece of evidence from which we get that substantive piece of evidence. So therefore, in certain cases, save the class. In otherwise, corroboration is required for the purpose of finding out that conviction. This is how that Rameshwar case ends. Then I have narrated about this substantive piece as well as the corroborative piece. Before getting into this, these are the pre subject which we are bound to know, that before getting into the Evidence Act. Now we will go to the Evidence Act, section 3 of the Evidence Act. We will start from the section 3 of the Evidence Act. Then we'll have to understand first what is fact. We'll have to understand fact and issue. We'll have to understand what is relevant fact. Accordingly up to not fact. So for this purpose, I'll try to share the document, whether just see whether the document is coming or not. Is this document is coming, madam?
No, sir.
Is this document is coming?
No, sir.
No.
It's not coming.
God. Last time also same problem. So. Right. Share document. Now is it coming?
Yes, sir. The screen
Yeah.
has come.
Yeah.
Ah,
Yeah.
yes.
Yeah. See, we will start from this section 3. Fact is a very basic fact, basic thing that so without teaching this, it will be very difficult for me to go into the Indian Evidence Act. So we will have to touch this, then only we can go into the Indian Evidence Act. So please bear with me. Fact is stated as anything, state of thing, relation of thing, capable of being perceived by senses. So I have missed one other thing. Whatever is deposed by the witness that A attacked B, A attacked B on head, A attacked B on chest. These two things were perceived by senses or not? Perceived by what? Perceived by my eyes. The five senses is eyes, then nose, then hearing, then smelling, then what do you call the tasting, then the feeling. These are the five things. So all the five things had been given here in the illustration. So we see that illustrations, and we speak about the fact. The fact includes a lie also. Lie also becomes fact here. See, anything, state of thing and relation of thing capable of being perceived by senses. So it includes everything which could be capable of being perceived. My taste. At particular point of time I had that sensation of some fire, whatever it is. I had a feeling of rain coming. I saw the rain is falling down, and it's a large sound is big sound is I'm hearing a big sound. This is also a fact. All these things are fact. That's why it's called that anything, state of thing, relation of thing capable of being perceived by sense. Whatever you perceive by your senses, it will fall under the ambit of fact. This is number one. Number two is the most important thing, that it is the mental condition of which a person is conscious. I am conscious of I have a mental condition. I am conscious of it. I have a mental condition to kill B. I am sharing it with somebody else. So we should eliminate him. You have a common friend, enemy, I have a common enemy. So we both have a common enemy. Somehow he has to be eliminated from the earth. So if that is a case, the mental condition of which I am conscious, but it's not been disclosed to anybody else. It's a shared agreement. It's not a written agreement, it's a shared agreement. So the mental condition of which a person is conscious is also a fact. This is what's been defined in the. So if you take the illustration, if you see the illustration says whatever I heard, any object that's been arranged in a particular manner, anything I heard, anything I saw, anything, the certain words, the man said certain words, I hold certain opinion, I hold some intention or a good faith which is fraudulent or good faith. I have an intention which the intention is good faith, or this might be also fraudulent, and particular word in a particular sense, and of the specified time conscious of the particular sensation. I said that fire, I said the particular time I got a sensation of fire. So these are the things which constitute the facts. The fact, intention, knowledge, if you want to take the intention, you have to go to section 14 of the Evidence Act. Knowledge, section 14 of the Evidence Act. All these things constitute the fact. So these are the things, anything I see, anything I saw, anything I hear. So this section 3, this fact, has to be compared with always, whenever you get into the fact, whenever get into the illustration of the fact that I heard, I saw. We will have all confusion with respect to what is hearsay and what is heard. Here it is say heard. It says that heard. I heard something. Can it be said that I go and depose before the court? I heard that man while he was being attacked, he shouted, ஐயோ அம்மா என்னை வெட்டுறீங்க அப்படின்னு சொல்கிறாரு, அப்படி சொன்னார் அப்படின்னு நான் சொல்கிறேன். ஐயோ நான் செத்துட்டேனே, அப்படி சாகர போகிறேனே அப்படின்னு சொன்னார் சொல்கிறேன். I heard, I go and depose before the court. Whether it is a hearsay, whether it will be hit by hearsay rule, it will not hit by hearsay rule. So therefore, you have to compare section 3 illustration along with the section 60 of the Evidence Act. Section 60 says it should be direct. It should be direct, and it should be any facts could be deposed by means of the oral evidence. That is 59, and it should be direct. That is what the 60 says. For this 60, it should be direct. There are two exemptions. One is exemption number 6. The exemption number 6 is the section 6. any statement or any fact which is falling under the part of the same transaction. That becomes 6. Number 2 is any statement which is falling under the section 32 of the Evidence Act, dying declaration. I hear that man has been now hit. He says something that A and B joined together hit me, and the moment he said that, he died. That declaration, the statement which he has given, it's become a dying declaration. So that dying declaration, when I go and depose before the court, is it a hearsay? Can it be objected by the defense saying that no, it cannot be admitted, it's a hearsay? Hearsay is therefore, it is exempt. Therefore, you have to, hearsay is therefore here exempted. Here exempted. I'll give a clear picture about hearsay and what is hearsay and what are the occasions in which it is irrelevant fact. What are the occasions it will become a relevant fact? So for that, I'll give some examples for it. Now, it will not attract section 660 and it will become admissible under section 32 of the Evidence Act. Suppose if the having heard, if it falls under section 6 of the Evidence Act, that is forming a part of the same transaction. He was being hit and simultaneously she is shouting that A and B are hitting at me. I am going and saying that, so this is what has happened and A and B are hitting at me, he shouted like that. It is a part of the same transaction. You are in the next room, you did not see A and B hitting that victim. A and B hitting the victim was not seen by the person who is X, who is in the next room. He hears only the voice. He hears the voice alone. He is not witness to the eyewitness to the occurrence. But at the same time, the voice goes there. It is also will fall under part of the same transaction. If he goes and says before the court, it will not hit by heard as a hearsay, but it will be taken under section 6 of the Evidence Act, saying that he has also heard the sound at the same time when victim is being attacked. Suppose, assume that X go and says to Y, some two persons hitting someone there. I got a news, I got a sound, and this is what the sound I got. Ayyo Amman Kedichi. That is told by X to Y. Y goes and says before the court. Now the Y is hit by hearsay evidence. This is how the hearsay evidence has to be seen. Hearsay, what I directly see. Suppose I directly see and I come and say before, say I declare or I come and say to you, convey to you. I convey to you saying that two persons have been hitting one person. He was shouting like Ayyo Amma, and by this time he would have died. And I saw that occurrence. I am a direct eyewitness and direct heard witness to the incident. Suppose if I come and say to you, and you go and depose before the court, you did not hear it, you did not see that, but you heard it from me, and it becomes a hearsay. I am not becoming a hearsay, but you are becoming a hearsay. This is the difference. Please understand the difference of it. Always hearsay, it's not the hearsay. Hearsay is meant for something else. He heard something without seeing that picture. He heard something without hearing the sound emanated from the same transaction. If those cases are attracted, then it will fall under section hearsay and it will not be admitted before the court of law. Otherwise, it is admitted in the court of law. This is for the example I am saying. Please compare the section 3, 60, then 6 and 62, which are all connected sections, which whenever you deal with one of this, you have to keep that 6 and 32 also, so as to 6 and 32, if it falls under 6 and 32, it will be admissible. It will get admitted. That you have to always keep it in your mind. Otherwise, it will fall under, if it does not fall under 6 and 36, which is admissible, otherwise it will fall under hearsay evidence, which is not admissible. This is the fundamental thing which you will have to know about it. Then comes the relevant fact. Relevant fact is whatever I said. I said already that any of the facts which had been narrated from section 5 to 55 of the Evidence Act, which is the relevancy chapter, that I think this is chapter number 3 or so, and this chapter, whatever it falls, that is relevancy. So relevant fact is defined here. One fact is said to be relevant to another in any other way it's connected, any one other way, one fact is said to be connected to another when one is connected to another in any other ways referred to in the provisions of this act relating to the relevancy. That is 5 to 55. If it is not connected in 5 to 55, if one or other fact is not connected to section 5 to 55 of the Evidence Act, then this fact is not at all relevant and it will go as a irrelevant fact. Unless otherwise it falls under section 11 of the Evidence Act, that is alibi, that we call it alibi. We'll go through that. Okay, we'll come to that also. So the relevant fact in issue, relevant fact. Then the most important thing here is the relevant. What is fact in issue? Fact in issue is a fact, it's a direct fact as to the occurrence. This fact will give a right or liability. The fact in issue. What fact? This is a fact in issue which will give a right, which we will take, that better we can take a criminal side. So for the easy understanding, if you go to the civil side, we'll have to go for the right, title and interest. Right, title, interest. I'm not going into that, but presently I am confining myself to the criminal side so as to get a better understanding. Same thing you can apply in the civil side also for the civil facts. But understanding purpose, criminal side will be more interesting and it will be more application oriented also. So fact in issue, if you say fact in issue means and includes any fact. That's what any fact is. Anything, state of the thing, relation of thing capable of being perceived by senses. Any fact either by itself தனக்கு தானாகவே அல்லது or in connection with the other facts, இன்னும் மற்ற facts கூட சேர்ந்து the existence, non-existence of the liability. We are dealing with a criminal. Civil right and liability is a word here. Please understand, please see this right and liability is a word here. Is my marking is seen, madam? Right and liability is the important word here. Now we will say for the criminal purpose liability alone. So either by itself or in connection with the other facts, the existence of the liability is asserted by the prosecution. Existence of the liability is asserted by the prosecution. If it is a defense, denied by the prosecution. That is simple. See, the fact in issue, the expression fact in issue means and includes any fact from which either by itself or in connection with the other facts, the existent, non-existent, nature, extent of any right or liability or disability asserted or denied in a suit or proceedings which necessarily follows. Therein is a matter. If you simplify this phrasage, you will get a fact which is either by itself or in connection with the other facts, so many other facts. The existence of the liability is asserted by the prosecution. Existence of the I deny that liability. Simple. So when they go for existence, I will go for non-existence. So you say that murder occurred in Delhi, Madras. I say that I was in Kumbakonam at that time. So there is an existence. By saying that I am in Kumbakonam, I say that I am not existent in Madras, Chennai. So this is how the difference. This is what the meaning. Entire thing is dumped into this. The entire Evidence Act, the elaboration of the entire Evidence Act. It is a concise Evidence Act has been dumped here. Fact is either by itself or in connection with other facts. I am again and again repeating. I would have read it so many times. Again and again I am reading. Even now I am reading. Either by itself, the fact either by itself or in connection with the other facts, the existence, non-existence, nature, extent of right, liability, disability is asserted or denied in a suit or proceedings. For simply saying for a prosecution, they will tend to exist, they will tend to make that existence of the liability, assert the liability. That's it. So for that liability, we deny the liability. We are not concerned with the fact and issue. We take a defense that we are not concerned with the fact and issue. This is how the fact and issue has to be seen. So these are the three important areas which we have covered. Then we come to the document. What is the meaning of the document? Document means any substance. It may be a letter, it may be a paper, it may be a stone, it may be now electric media, magnetic media, pen drive, CD drive, hard drive, and even it is a stone, it may be a stone, it may be a leather, any substance on which any matter is expressed or described. Any matter is expressed or described in by way of a letter, mark and figures. Anything else, letter, figure, mark இருக்கணும். எனி சப்ஸ்டன்ஸ், இது எந்த சப்ஸ்டன்ஸ்லாம் தண்ணியில் எழுத முடியாது, தண்ணியில் மட்டும் உங்களால் எழுத முடியாது, காற்றுல எழுத முடியாது. These are the two things which are completely excluded. Otherwise, it says like anything in the fact, it says that any substance on which any matter is expressed or described, any matter is expressed or described means of the letter, figure, marks. So this is called a document. This document, when it is produced for the inspection of the court, it becomes the documentary evidence. If it is not produced for the inspection of the court, it remains as a document, it remains as a material. When it is subjected for the inspection of the court, it is having a solemnity. This material, this document will be turned into a documentary evidence. It becomes an evidence before the court of law. So this is how the document is expressed here. Document is so important thing which you have to keep it in your mind. And for the purpose of seeing that all are document, FIR is a document, the postmortem report is a document, the 164 statement is a document, TAP report is a document, a sperm report is a document, DNA report is a document, fingerprint report is a document. When it still it enters into the court, it remains as a document. Once it enters into the court and subjected for the inspection of the court, it becomes a evidence. And if it is going to be marked to the author of the court, then it becomes an appreciable evidence where the court can appreciate it for the purpose of effecting the conviction, for being a well-founded conviction. Okay, this is a document definition that's given in the section 3 of the Evidence Act. Then we'll go to section document, then evidence. What is evidence? Then evidence is stated here. Evidence is stated here into 3 types, that is oral evidence, documentary evidence and electronic evidence. Oral evidence, whatever is deposed before the court. Then if it is a oral evidence, you will have to immediately jump from section 3 to section 59 and 60 of the Evidence Act, which deal with the oral evidence. All facts could be deposed, all facts could be proved by means of a oral evidence. There is no distinction except the documentary evidence, contents of the documentary evidence. Except the contents of the documentary evidence, all facts could be proved by means of the oral evidence. All statement which court permits and requires. You see, these are the 2 keywords which I earlier told. The all statement which the court permits or requires to be made before it in relation to the matter under inquiry, in relation to the matter under issue. Then these are the two important key verbal verbs you have to keep it in your mind is permits or requires, mandates. I permitted it, or sometimes I will mandate it. You file it, you have to mandate, you have to file it. No other option for it. Requires the court to file it before it. So these are the two things. All the statements which a court requires or permits to be made before it is the evidence. This is called oral evidence. All documents and the electronic records, including the electronic records. Now it's been included. Electronic records have become a part and parcel of the documents. We said that any substance on which anything engraved, in that substance, what is involved is, what is included now is the magnetic media, optical media, and this pen drive, and apart from the pen drive, this hard drive, and the CD drive. All these things have become substance. All the substance, whatever is written over it, whatever is copied over it, whatever is stored over it, whatever is recorded over it, all this become now document. That's why it's been included in the document. Document includes electronic record which is produced for the inspection of the court. Unless otherwise inspected, it remains as a document. Once it is inspected, it becomes a documentary evidence. So this is the basic aspects of this section 3 of the Evidence Act. Okay, then we will go further into the section 3 of the Evidence Act, which are very mandate to require and proved. How it is, the matter is proved, disproved and non-proved. All these three are interlinked. And once you get into the proved, what is the meaning of the proved? Once you put a negative form of it, you will get a disproved meaning of the disproved at all. So that's such a beautiful coinage that's been given in about 1872 by Sir John Stephen, very long ago, 170 years back. So it's still it's a act which still remains unamended. Major amendments are not being seen in this act. If you ask me that, I'll say this is a machine to filter the truth and to separate the falseness. So what is truth and what is false? This is a machine. It is not. Its overall framework is on the basis of the human behavior. How the human will behave in accordance with the guilt or in consonance with the guilt or in consonance with the innocence. How his behavior will be, and we'll have to analyze this behavior on the basis of his material which is available before the court of law. This is the mechanism in this Evidence Act. Then we'll go to the proved. What is the meaning of the proved? The proved is a fact is said to be proved when, after considering the matter before it, court either believes it to exist or consider its existence so probable that the prudent man ought to act on upon the supposition that it exists under the circumstances of a particular case. I'll once again read it. Very patiently I'll read it. A fact is said to be proved when, after considering the matter before it, court either believes it to exist or consider its existence so probable that prudent man ought, under the circumstances of the particular case, to act upon supposition that it exists. These are the importance of the proved. How the proved is taken into consideration, defined in the Evidence Act. So, when I narrated the substantive piece of evidence, you have to take this definition also into consideration. When the court, considering the matter before it, court is believing that what is being deposed. Court believes. These are the two important things. The court believes or supposes. I suppose this should have happened. I believe that this has happened because of the wording of the witness, because of the testimony of the witness. I believe that. Once I believe that, it becomes a substantive evidence. And this is how this belief and the supposition that it exists, that the existence is so probable that prudent man ought to act on the supposition that it exists. Suppose a witness comes and says the sun came from the south. Is the judge bound to believe it? It's on oath, it's on box, it's on the witness box, it's on the oath has been administered. Is it bound to believe? I cannot believe it. As a prudent man, I cannot believe that. I suppose that it is not prudence. So, therefore, the two powers that's been given to the court is a believing power and a supposing power. Supposition of what? Whom? Supposition of whom? Then question comes, the supposition of whom? First one is believing. I believe. I myself believe on the basis of the statement that's been given to me. I believe that on oath and administration of oath, the statement has been given. I believe that. And if I suppose I believe that, then comes a supposition. Next, suppose I don't believe that, I can also suppose. In that supposition, how I suppose? I suppose a man of the prudent man. I will stand in the shoe of the prudent man and I will see that whether I can suppose this or not. Supposition as to what? Supposition as to existence. Whether this exists or it does not exist. The fact exists or does not exist. So these are the two important keyword which you have to keep it in your mind, that there is a prudence, there is a supposition, there is a believing. So if you reverse it, believe, suppose, supposition in the shoes of the prudent man. In the normal prudent man, if he supposes that this exists, then the court can believe that also. If the supposition the court feels that does not exist, then I can simply reject. He is a liar and he is not saying the truth. No weightage could be given, no sufficient. It will not be sufficient to affect any conviction. Total outright rejection also could be given to that. This is how it has. The framework is given here in the proved. If you go to the disproved, I said that the prosecution will tend to prove a fact. Tend to prove a fact on the basis of the fact in issue or a relevant fact. We, the defense, will always tend to disprove it or make it as improbabilize it. We will improbabilize it or we will disprove that. Disproving that I am in Kumbakonam or Trichy, I can say that it's a disproving. I can also improbabilize the case of fact in issue and relevant fact, which the prosecution will tend to prove it. The prosecution will tend to prove, we will disprove it. So please see the wordings in the disprove. The fact is said to be disproved when after considering the matter before it, it's a matter, it's not an evidence. Since we are considering the 313 question, which is not an evidence, we are seeing the demeanor of the witness, we are seeing the court atmosphere, all these things are seen. So therefore it is not confined to the evidence, it is confined to the, it is a matter. Here also, in the proved also, if you see court after considering the matter before it, if you check the Attack Pandi case which were recently delivered with the Honorable High Court, this word has been very quietly used, that it's a matter, it's not evidence. I am not going into the evidence. I may not be going into the evidence. I may go look into the whole matter, whether A is accused is culprit or not. If you can go through the entire judgment, 137 pages judgment, you can find it out. The matter has been used there. They say there's no evidence is an argument. They say that no, it's not required. I have to see the evidence. I have to see the matter before the court. What is a matter before the court of law which needs to be adjudicated, issue of which needs to be adjudicated. So that is how the court went on, and the trial court acquittal has been reversed, and the conviction has been granted. Conviction has been effected in the Attack Pandi case. That's a Madurai case, very interesting case. If anybody interested, you can go through that. Disprove, we'll come to the disprove. A fact is said to be disproved when, after considering the matter before it, court either believes it to exist or believes its existence so probable, believes its after considering the matter before it, court either believes its non-existence does not exist. Court either believes that it does not exist or consider its non-existence so probable, the Brudenman ought to act on the supposition that it does not exist. This is what the word. Here, there in proved it's completely in existence. Here it is completely, court believes that it is not exist. Court supposes, considers that its non-existence is so probable that the Brudenman ought to act on the supposition that it does not exist. Here the court considers, supposes on the Brudenman's shoe that it does not exist. At the same time also the court believes that it does not exist. This is how this proved and disproved has been believed. So if you can understand the distinction between the proved and disproved, we can take out our plea very quickly. We can take out our plea. What could be the plea before the court of law? What could be the charge? We will know. It's already been supplied under section 207 of the CRPC. You have the charge. You have what are the statement that's been given by the 161 statement that's been given by various witnesses. You can simply say these are the things non-exist. If the accused has really not committed the murder, certainly he can escape from this conviction. If we go through all these provisions very carefully and in depth, after reading it, it has to be applied in the practice also. If it is going to be applied in the practice, certainly we can hit the evidence, we can win over the evidence or win over the witness, so as to say that witness has been imported or it's an implanted witness, is biased and partition which cannot be believed and could be thrown, no weightage could be given, it's not sufficient, no weightage could be given. So this is how we can go with all the eight definitions, the basic definitions I have given with respect to this Evidence Act, and we will go to section 4. 4 is a presumption. That I said that belief is one. I considered supposition, prudence is another thing. I suppose, court will suppose that it exists or suppose it exists or non-exists. And the section 4 is the may presume, shall presume and conclusive proof. If it is a may presume, the court may call for, if it is a may presume, the court may call for proving that fact. You prove it. No, I will not presume it. You prove it. If it is stated, declared, that it is the court shall presume that evidence, then the court shall presume that the court shall having regard to such fact unless otherwise disproved. The court shall presume that it is proved unless otherwise you disprove it. You disprove it, I will say that it is not been in existence. So this is how the shall presume. Shall presume is little more veracity, little more powerful when compared to the may presume, and it says that whenever directed by this court shall presume a fact, it shall presume such a fact as proved. It's proved until otherwise disproved. Suppose the other side does not prove it, does not disprove it. The defense does not disprove it. The court shall take it that it is proved. This is the definition of the shall prove. Then comes the conclusive proof. When one fact is said to be declared to be conclusive of another, court shall on proof of fact A, one fact, it shall regard the other as proved. Birth has happened, child has born, you both are living together. What would be the presumption? Presumption is there is a marriage. Child has born, that has been proved. There's a birth certificate has been, father name is so X, mother name is Y. So the certificate has come. So what is the presumption? You are now coming and settling in one town. You are earlier in some other town. What would be the presumption on the basis of the certificate and birth? The birth is a conclusive proof of the marriage. That's what is defined in some 111 or 12. Birth is a conclusive proof of this is a definition clause, that's an example clause. So the birth is a conclusive proof of the marriage. This was also a presumption can be raised on the basis of the proof of one fact. The other facts could be proved. This is what has been defined in the conclusive proof. Then we will come to the section 5 of the Evidence Act. Section 5 now deals with already I went there and there was a breakup and I am now elaborating here. Okay. The evidence, what is the mandate given by the section 5 is that evidence could be given as to the existence, non-existence of every fact in issue, every such other facts which are declared to be relevant in the provisions relating to the declared to be relevant and of no others. Where it is declared to be relevant? The declared to be relevant is falling under section 6 to 55. So if it is not declared to be relevant, then can it be taken into evidence or not? Can it be given? Evidence can be given on it. If it is not declared to be relevant, can it be given as an evidence? It cannot be given as an evidence is answer. Section 5 is the entry point for the Evidence Act. Evidence could be given, again I will read it. Evidence may be given in a suit or proceedings of the existence, non-existence of every fact in issue. Every fact in issue. A had a knife. A went to his house. A jumped over the compound wall. A went to his bedroom. A attacked him on chest, attacked on everyone is a fact. Every fact in issue and every fact, other facts which are declared to be relevant and of no others. And of no others. This and of no others, you have to compare it with the section 136 of the Evidence Act. You have to compare it with section 138 of the Evidence Act, what is chief and cross, and you have to compare it with the 148 of the Evidence Act. So if you compare it with the 3 sections and also 165 of the Evidence Act, 165. If you compare the section 5 with the 4 other sections, 136, 138, 148 and 165, you will really come to know the evidence could be confined only to the relevancy. Even if it is a chief and cross, it could be confined only to the relevancy. You cannot go beyond the relevancy. If you go beyond the relevancy, judge is having some very wide power under section 149 and 150, which we will go when we will take it when we will discuss about that when we are taking that chapter examination of the witness. So section 5 is the entry point for getting into the Evidence Act. The evidence may be given as to existence and non-existence of the fact in issue and every other facts declared to be relevant and of no others. That's a specific barricade that's been put. You cannot cross over the barricade and jump into the Evidence Act. No others is a barricade. It has not been simply just left out. It's not been simply left out that hereinafter declared to be relevant. No, there is a specific barricade that's been given, that and of no others. If you jump the and of no others, you will land up in section 150 of the Evidence Act. The report will be forwarded to the Bar Council. Our report also might be forwarded to the High Court. Pertaining to the circumstances, the questions have been asked unreasonably. That is what stated in the 149. This is the evidence entry point. Then we will go to the next. I think that you have understood up to this the section 5 of this Evidence Act. Then we will go to some of the illustration that's been given here as to what are the fact and issue, the relevant fact, and the existence as to which the evidence may be given. And section 6 now comes the real the relevancy area. The section 6 to 655 are the real relevance area, which shows that part of the same transaction. I told you that it's a part of the transaction. I told that Rameshwar, state of Rajasthan, see girl saying to her mother, I have been raped. This is one example which already we have discussed. It's a part of the same transaction, and also at or about the time when the incident has happened, and on the basis of which the complaint is also lodged. See, the difference is, if the section is going to, if the statement is going to fall under section 6 of the Evidence Act, somebody is hitting somebody, I am hearing the sound, and the neighboring, the person who is residing in the next room is also hearing the sound. What the sound I said, he is also saying the same thing. We both are not hearsay, we are direct evidence, deposing under section 60 of the Evidence Act. We are saying that. If it is going to be a direct evidence, if it is going to be, it's going to be a direct, if it's going to be a direct one, if it's going to fall under section 6 of the Evidence Act, it is certainly, it will fall under the part of the same transaction, which is also a substantive piece of evidence. Unlike 157, it is not a corroborative piece. 167 specifically says it's a corroborative piece. It only supports strength to the substantive piece. Corroborative piece is, I already told, the substantive piece is a pillar on the base of which the whole building will stand. Once you cut one of the pillars, the building will collapse. The case of the prosecution himself will collapse. This is a pillar on which the case of the prosecution stands. We can say that that pillar is the substantive piece of evidence. The other things are the supporting things like bricks, putting one brick on another, some windows, some stands, some elements which are giving a support to the pillars, or closing doors and all. All these things are corroborative piece of evidence. Even the plastering with the cement, plastering with something else, plastering with the tiles nowadays to make it beautifying it. All these things we can take it. This is the best example for this corroborative piece. Corroborative piece is nothing but the supportive piece of evidence. But without the pillar, only on the basis of the corroborative piece of evidence, whether the case will stand. It will not stand. It will be like you have a mud house that is built in the seashore. Anytime this wave will come and wash away everything and it will go out. It will not stand at all. It is like a corroborative. Without substantive piece of evidence, if corroborative piece alone available, no use at all. Absolutely no use at all. So one example I can say, but I don't think that the time has come for saying that. It's a deposition of the witness under section 164 of the CRPC. It's a witness. It's called Muriasan versus Mecheri Police Station, Muriasan versus State. You can the audience can note down this case, where if you want to really see that what is substantive piece, what is corroborative piece, how it has been dealt with. Its Honorable Justice P.N. Prakash has dealt with this case, and substantive piece, corroborative piece, and it's a 164 statement. This has been recorded. Both PW3 and PW4 will record 164. They will go and say 164 statement before. The simple thing is that accused will attack the deceased with the cricket bat. He will run away. PW3 and PW4 are the eyewitnesses as per the prosecution case. PW3 and 4 will go and record the dying declaration, not record the statement that we have seen that the A was attacking the deceased with the bat and he was running away from that. Now there is a 164 statement which is available. When 164 statement which is available now before the court, this PW3 and PW4 did not mention anything about the 164 statement. Never said that we went and deposed. At least people should have asked that whether you gave the 164 statement, and this is what the 164 statement which is given by you to the magistrate. No such question was asked. Subsequent to the PW3 and PW4, the magistrate comes and deposits before the court. When the magistrate comes and deposits before the court, magistrate says this was the 164 statement that were given by the witnesses, and through the magistrate it was marked. It was marked to the magistrate. It was accepted or not accepted before the trial court, I don't remember, but in the high court it was slammed, saying that there is a corresponding substantive piece, corresponding corroborative piece of evidence available. No substantive piece of evidence was available corresponding to that, and PP has miserably failed in his duty in not showing the 164 statement to the person who gave the 164 statement, and it was not at all shown. It was not at all accepted. The witness also did not accept that this is what the statement that I have shown to the given to the magistrate, and should have been marked only through the author. All the three things had been miserably failed. It's not been marked through the author. It was marked through the magistrate. Then the court came to the conclusion saying, what the conclusion that the court is saying? Court is now saying there is the corroborative piece of evidence available, but corresponding to that, no substantive piece of evidence is available. A substantive piece of evidence has to be deposed only by the maker, not by the magistrate. This is the difference between the two things. The 164 statement, though it is having some evidentiary value, it's being a corroborative piece of evidence. It should corroborate. Once a substantive piece of evidence is given, this statement which is given to the magistrate will corroborate the statement given in the court. It will strengthen the statement which is given in the court. This is how the substantive piece, and it's a further understanding. I am saying this for the further understanding of the substantive piece of evidence and corroborative piece of evidence. Please understand. Now we will go to the section 6 of this Evidence Act, which is a part of the same transaction. Said the neighboring room, I myself heard, it has to be compared to section 60, and 60 exemption to the 60 is falling part under section 6. It is, even though it is not direct, it could be a evidence before the court of law. And also the 32 is somebody is dying and he is coming and deposing before, he is coming and giving a statement to me that he has hit me and therefore I am suffering a lot and paining, I have to go to the hospital. Suppose this is a statement, he dies after that, I go and depose before the court, that this is what the statement, it falls under section 64. Though it is not direct, it's not required that a dying person should go to the court and say that it was happened that therefore I died. It cannot be, and it cannot be, it cannot be said. He cannot go and say like that. And at the time of incident also, he cannot directly go to the court and he say that he hit me, therefore without being FIR take my statement on record. That's also a different. So these are certain exemptions that's been carved out, that for the purpose of section 60 and 6, that these were the sections which will not come under the hearsay and it could be admitted as an evidence. This is falling under the part of the same transaction. Res geste, we also call it as a res geste, which is the hit by hearsay evidence. Then comes the 7, occasion cause effect of the relevant fact. The facts which constitute the occasion, the facts which constitute the cause, the fact which constitute the cause effect are all relevant. For example, the observation Magadha that's been prepared. For example, this the sketch that's been prepared. These are all the things which are falling under the section 7 of the Evidence Act. Occasion, cause and effect. And also, if you down the bottom, if you see the facts which constitute the state of thing. The facts which constitute the state of thing and afford an opportunity for the occurrence. Which constitute the state of thing, afford an opportunity. We cannot see a much difference between that, but still if you go deep into that, we can see some difference. For section C, if you read the Mr. Ramraj case, I think, Ramraj was a state of Tamil Nadu, in which a small boy who is getting into an army enclave got fired. He will be fired by a rifle and he will die. He will fall down and other boys will run away. There will be 4 boys who will be getting into that army enclave, and one of the boys will get the injury and other 3 will run away immediately. The neighboring lady will say there was a blasting sound, such as like a tire blasting sound that I heard at the time, and the 3 boys were running out of the scene. So judge took note of this, all the 3 incident. It was taken as a part of the same transaction. What is that part of the same transaction? The sound which was a blasting sound, which was a tire busting sound which he heard. Number two, the boy who fell down the same time when the tire was busting. Number 3, all the 3 boys were running, fearing that somebody is firing or some knocking sound is heard. So these 3 things are part of the same transaction, which are admissible as evidence, which are relevant and admissible as evidence. This is how in the judgment it has been dealt with. Ramraj versus State. You can please go through the judgment. It will help you to understand various provisions of the Indian Evidence Act. It's very beautifully written and elaborately discuss about section 6, section 7, section 8, section 14, section 21 and other sections also. I have forgotten. So the 5 sections which I can say that. These were the 5 sections which very, very beautifully it's been narrated. Section 5 is an occasion, cause and effect, and it also constitute the state of thing. It also offered an opportunity for the purpose of this fact in issue and relevant fact to happen. These are the things which are falling under section 7 of the Evidence Act. Then comes the 8 of the Evidence Act, which is motive, preparation and subsequent contact. What is the motive for this Ramraj to fire at that was also dealt with that. The motive is it's an urge to commit an offense, urge to have a grudge over somebody else to do something else. Something ill to them has to happen. This is an urge inside the body that something ill to has to happen. That's different from intention and bad for the intention. That's totally different. Here, the motive is some ill will towards the person, some ill to be carried out to them. This is how the motive has been. Motive, preparation, subsequent conduct. See, motive, conduct also come here. Previous conduct is coming here. Subsequent conduct is coming here. All these things are, if any deposition is going to be there pertaining to motive, this will fall under section 8 of the Evidence Act. It will be a relevant and it will be admissible fact. This is section 8 of the Evidence Act. Motive, preparation, subsequent conduct. What is the motive as far as the Ramraj case is concerned? The motive of the Ramraj case is concerned, that area that the army enclave will be filled with lot of what you call this mango tree, badam tree and all, badam kotta. So these people used to, being a young boys, aged about 8, 9, 10 years old, they used to jump into the compound. Though it's a secured compound, army enclave, they used to jump into the compound, they used to pick up all these fruit bearing things and they will come out of it. While throwing the stone, that stone fell down on the windscreen of the Ramraj, his Colonel Ramraj. This become a motive. Immediately, thereafter, whenever this boys comes, his primary duty would be to go and run. He will run, chase the boys and keep them away from the compound, and he will return back to the house. This is what the conduct. That's been deposed by one of the servant maid. That's it's a neighboring servant maid. She will depose. See, from out of this evidence, deposed evidence, the court will come to the conclusion. The accused, Mr. Ramraj, chasing the boys out of the compound, it shows the angry disposition of the accused towards the boys. Angry disposition is something like, so whenever they come, no, I'll kill them like anything. So some angry disposition was the conduct. From out of the conduct, it was exposed the angry disposition. So from out of this angry disposition, which is falling under section 12 of the Evidence Act, I think 12 or 14 of the Evidence Act, then he will go to section 8 of the Evidence Act, that motive. So this angry disposition and conduct, it clearly exposes his motive under section 8 of the Evidence Act. Therefore, it is relevant. So therefore, he must have done it. Ultimately, one of the pinpointing issue, one of the things that is pinpointed that he should have done it is, this is the conduct. So this is how the conduct is elaborated in this Ramraj judgment. Kindly go through that. Then comes the section 9. 9 is the necessary facts. What are the necessary facts which are required for the purpose of introducing and explaining the fact in issue and relevant fact? See, this we will call it as section 9 could be used for the purpose of identification parade. Simply saying, why? Because it is used for identifying anything else. You see, it explain necessary facts. These are the necessary facts to explain, introduce the fact in issue and relevant fact, or which support or rebut the inference suggested by the fact in issue relevant fact, or establish the identity of anything, or identity of relating anything, or identity of anything, or fixed time or place at which the fact in issue and relevant factors happen, or which the relation of the parties by whom the fact was transacted. These are the 5 things that's been defined here. What is the first thing is that explain and introducing the relevant fact, support and rebut the suggested by the fact which is suggested by the fact in issue and relevant fact, and establish the identity of anything, identity of the time. That's most important. Identity of time is the identity of the dead body, identity of the place, identity by what time the death has occurred, and the time and place, and the relation of the party by whom it has been transacted. These were the important things which you'll have to keep it in your mind. Not only the identification parade, identification of time, identification of the place, and also the support and rebutting the fact which is giving an inference as to fact in issue and relevant fact, necessary to explain the introduce and facts necessary to explain and introduce the fact in issue and the relevant fact, which is necessary to explain the fact in issue and the relevant fact, which may not be directly relevant fact, which are necessary to explain and introduce the fact in issue and relevant fact. These are the facts which are falling under section 9 of the Evidence Act. Then we will come to the section 10, which is a conspiracy of this Evidence Act. The conspiracy is defined here. If there is a reasonable ground to believe that two or more persons have conspired together to commit an offence, anything said, done or written by them in course of their conspiracy are relevant as against each of the persons so conspired for the purpose of proving the existence of the conspiracy, for the purpose of showing that such person were the party to the conspiracy. These are the important. It's a reason to believe that two or person enter into conspiracy, and anything said, done or written during the course of the conspiracy are all relevant. We can take that what is said, done. There is a meeting of mind. What is a meeting of mind? We want to do an illegal act. Some two persons are joining together to meet an illegal act. So this illegal act is done by illegal means, or any legal act by doing an illegal means. These are the things which are conspired to be done. But during the conspiracy, that before being executed, before the offence being committed, so we are doing something. What are the things? We do something, we write something, we written, was said, done, written. We did something, we wrote something, and written. Anything said, done, written by any one of the conspirator. I am doing something, writing something. So whatever I write, whatever I do, whatever I did, all this will fall under Section 10 of the Evidence Act, which is relevant and also admissible as evidence, on the basis of which the conviction could be granted. That's the difference between the section. This is a substantive piece as against the, if one of the conspirator goes and gets some knife, one of the conspirator, the other one did not go, but ultimately both of them joined together to commit that offence. So this going and getting a knife, and the shop owner coming and deposing before the court that they came and get the knife. I do not know the purpose. They came and get the knife. Then it's a thing that is done by them. So this their deposition to the effect it's done. There was a conspiracy. On the basis of which the court can come to the conclusion there was a conspiracy. Then these were the two persons who were involved in the conspiracy. These were the party who were involved in the conspiracy. The existence of the conspiracy is different and accomplishment of the conspiracy is different. These both are distinct offences. It is always not required. Whenever the conspiracy has been committed, we have to ultimately commit the offence. It is not required. The conspiracy itself is a distinct offence for which the separate punishment is awarded, and the accomplishment is a separate offence, therefore which the separate offence, separate punishment is awarded. Suppose assume that the conspired is the murder. For the murder, there is a conspiracy, and the murder has not been accomplished. Murder has been left out before that, but the conspiracy alone has been done. That itself is a distinct offence. Therefore, the charge should be 120 be read with 302. That's simple as that. If the murder has not been done, if the murder has been done, then there will be two charges where 120 be read with 302 for the purpose of conspiracy, and the second one is 302 which was done in furtherance of the conspiracy. 302 read with 120b. So first one is 120b read with 302, that is a conspiracy. Second one is 302 read with 120b. So 302 120b mean what it means. The 302 has been committed, the murder has been committed in pursuance of the conspiracy. So the three important judgments I can say, the important judgments, that Banu judgment, if you can go through, the fastest son of the MJR, it's a very reputed judgment here, which was rendered by Honorable Justice Nagamuthu, and it's a very popular judgment here. I used to cite each and every lecture, I used to cite the judgment because it's a very easy way to understand what is conspiracy, what is section 24 confession, what is section 26 what is section 24, what is section 30 of the Evidence Act. These are the three important sections which you have to mind. So as far as the 30 is concerned, co-accused confession is the corroborative piece of evidence. This is also one of the corroborative piece of evidence apart from the former statement, apart from the previous statement in writing. Co-accused confession is also one of the corroborative piece. But with respect to the maker, if I am the maker of the statement, that is a substantive piece of evidence as against me. But with against the other co-accused, it is only a corroborative piece of evidence. It's also one of the corroborative piece of evidence which is stipulated as per the statute. So this is an important judgment where you will have to go through to understand section 10 of the Evidence Act, what is conspiracy, subsistence of the conspiracy, during the existence of the conspiracy, what are the things done, and 24, what is 24, the extrajudicial confession, and what is 30, the confession of the co-accused, what is a probative value of it, what is the evidentiary value of that co-accused conspiracy. These are the three important things which have been dealt with in the N. Banu's case, rendered by Honorable High Court of Madras, and you can go through this N. Banu's case also. And if you want the conspiracy part of it, then you will have to start from the Mirza Akbar. It's a very early judgment in 1952. Mirza Akbar is a very first judgment that has been pertained to the conspiracy in our history of conspiracy, where you can see that the wordings written by the letter transmitted between the two accused for the purpose of maintaining some illegal intimacy and murdering the real husband. So these are the two important things I can narrate. For the purpose of conspiracy, you can read it. Then comes the section 11 of the Evidence Act, which we very commonly we use in our practice. That is the facts which are irrelevant when it will become relevant. Irrelevant facts when it will become relevant. So if you see the wordings of this section 11, it will be almost similar to the section 3, fact in issue as well as the proved fact. How the fact is said to be proved. These are the very common words that's been used. I'll go through the words here. When the facts are not otherwise, facts not otherwise relevant become relevant, which is simply saying don't confuse with that word will become confusing. When irrelevant fact will become relevant. The facts which are irrelevant will become relevant if they were inconsistent to the fact in issue and relevant fact. Then number 2, if by themselves or in connection with the other facts they make the existence and non-existence of any fact in issue or relevant fact highly probable or improbable. So this is what the wording is being given. It will be confusing. You have to understand that you have to read it 4-5 times. So what is thing is that the fact in issue and relevant fact will always be used by the prosecution. Prosecution will tend to make use of this fact in issue and relevant fact in order to make the case is proved. In order to make the case proved, he will say that there is an existence of the fact in issue, existence of the relevant fact. This simple. Where in the opposite side defense, where what we will tend to do is, no, this fact in issue and relevant fact are irrelevant to some other facts. These facts are irrelevant facts. This fact in issue and relevant fact which are used by the prosecution are inconsistent to my facts. My facts are irrelevant facts. I was in Tamil Nadu. The incident happened in Andhra. These are the proof that I have. But for this irrelevancy, it will become. But for this section, but for this the fact in issue and the relevant fact, this will become an irrelevant fact. So when it will become irrelevant, I say that because I am an accused, I say that at that time I was in Tamil Nadu. So when I say that I was in Tamil Nadu, this irrelevant fact will become a relevant fact. What this irrelevant fact will do? This irrelevant fact is, number 1, it is inconsistent to the fact in issue and relevant fact. Please keep it in your mind, be clear. This irrelevant fact that I am in Tamil Nadu but the incident happened in Andhra, it is inconsistent to the fact in issue and relevant fact there. Inconsistent to the fact in issue. We will take it as inconsistent to the fact in issue, number 1. Number 2, then this irrelevant fact which I have, I am a defense. This irrelevant fact which I have, which will tend to make the existent and non-existence of this fact in issue and relevant fact as a improbable one. So this is called the preponderance of probability. What is the preponderance of probability? I prove myself on the basis of the evidence which I have, which are relevant. I was in Tamil Nadu. My probable view is that he was in Tamil Nadu at the time, how he could have committed the offence at Andhra. So this is the thing which is improbable. I make it as a preponderance of improbability. I am making use of it. I can also disprove it, that's totally different. But for before disproving, the disproving is the next step. But at least by means of the evidence or by means of the explanation which I give under section 313 of the Evidence Act, I can make that a fact in issue and the relevant fact which are made use of by the prosecution for the purpose of proving the case, to make a legal proof out of it. I can disprove or I cannot disprove that. I disprove is the second step. Even before that, I can improbabilize that by means of this non-existence. By means of the non-existence, I rely upon some irrelevant fact. When I rely upon some irrelevant fact, that irrelevant fact will become a relevant fact for the purpose of proving alibi. This is called alibi. We generally use alibi, but we have to see the section also what alibi really says. Okay. This is section 11 of the Evidence Act. Then we will come to the section 12 of the Evidence Act. It's a suit for damages which tend to enable the court to determine the amount are relevant. Then it's okay. Then right and customs. Then section 14 of the Evidence Act, state of mind, body, bodily feeling. This is a state of mind I said there while you were chasing. When the colonel was chasing the boys, his state of mind is exhibited. What is his state of mind? My state of mind is he is having some angry disposition as against the boys. So this is what is discussed in the section 12 and section 8. How both were connected has been discussed in the Ramaraj case. Ramaraj is the state of Tamil Nadu. You are requested to go through the case for the purpose of understanding the 14, state of mind, body, bodily feeling. And also it's so important thing in 14 is that the intention, knowledge, good faith, negligence, rashness, ill will, goodwill, all the acts are coming under this section 14. Intention and knowledge, which is discussed in section 299 and 300 of the IPC. 299 there are 3 limbs, 300 there are 4 limbs. First 2 limbs are intention limbs. Intention of causing death, intention of causing bodily injury. That is in 299. These 2 limbs are being divided there into 3 limbs in 300. Intention of causing bodily injury, intention of causing death first, intention of causing bodily injury which the offender knows that he is suffering with a disease, heart disease or some disease. I am attacking at the point and dies. Second limb. Third limb is an intention of causing bodily injury, where the intended injury is, the injury intended to be inflicted is sufficient and ordinary course of nature to cause death. Injury intended to be inflicted. Injury intended is the key word and the decisive factor. Suppose he wants to hit in the nail. It falls in the head, dies. Whether the intended injury is the head, it's not. The decisive factor would be the intended injury which is on nail. So this is how it has to be done. The third limb in 299 is knowledge. The knowledge falls here also in 14. Third limb is knowledge by doing an act with the knowledge that this act will likely to cause death. So there it is called in 300 it is given an aggravated form, doing an act with the knowledge that act is so imminently dangerous and all probabilities will cause death. This is how the knowledge the difference has been mentioned there. Unless otherwise it falls under exemption. If it falls under exemption, again you will land up in 299. The punishment will be under 3041, 304 part 2. Why I am saying this is because all you people are writing this examination for district judge. I am saying this. Suppose if it does not fall under the exemption, from 299 it goes to 300. You will land up in 302. Simple. The matter is very simple as that. So you have to compare the 299 300 for the purpose of understanding that. You have to come and see this section 14 of this, how this intention is relevant, how the knowledge is relevant when it is proved, when it is going to be adduced as evidence before the court of law. So section 14 is important for you. Section 15 and 16 and all is totally simple, very simple for you to understand. There's nothing so much to discuss about that. 15, 16. Then 17 comes the admission. Admission is nothing but any statement which gives an inference about the fact and issue and the relevant fact. It's nothing but a statement. It gives an inference about the fact and issue and relevant fact. Again, we are going back to the section 3 of the Evidence Act. Fact and issue and relevant fact. This is a statement which is giving an inference as to that. So 17 has to be read along with the section 3 of the Evidence Act. Then admission defined. All these are connected to the civil cases, which you can go through that, very easy for you to understand, nothing special about it. Admission is defined as suggested by the party. When party itself gives a admission, that is admissible. Then the party as its agent, this is 18. When a person whose position must be proved, suppose I am engaging an agent for the purpose of collecting the rent. That's what the illustration here says. For the purpose of collecting the rent, I am putting an agent for it. Agent does not give me the money. I sue the agent for the money. The one of the tenant comes and gives a deposition that yes, I owe money to me. So that is an admission. That is an admission which could be relevant and which could be admitted. This is called admission. This is one of the admission. Then section 21 is important for criminal purpose. Here section 21 says proof of admission against the person making them. Suppose I am giving an admission. This admission cannot be used in my favor. It could be used only against me. That's what this 21 says. Whenever the admission is given, it could be used only against me. Suppose I am facing a trial. I used a car. That car was used for the purpose of committing an offence. It went to the place of occurrence. It was recovered from the place of occurrence. And that car, ultimately, I filed an application before the court of law for returning of the property, where I submit that this car is my car and the car was registered in my name, and therefore return the car back to me. It tends to make it's an admission. It's an admission. This example which I have given now is used in the Attack Pandi case. Attack Pandi's car will come to the place. He will subsequently run away in the car itself. The car will be recovered, and he will make an application before the court that the car is required for me and therefore return the property. He will file an application for return of the property. On the return of the property, he will take out the car, and this was used against him in the court, saying that you yourself has admitted what is a car that has been seen there in the occurrence, which was photographed, which was seen in the photograph. It belongs to you, and you don't have any explanations for the purpose why this car exactly on the time it came to the place of occurrence, and therefore this circumstances was taken as against him. So this admission that he has made in the application was taken against him, that this car belongs to you. Number one, this is a good example for that. Number two, if you take the Ramraj case also, he will buy the gun from some Jodhpur or somewhere in Rajasthan. Subsequently, he would have got transferred, he would have come to Chennai, he would have settled. He will apply a license before the commissioner. In the commissioner, he will say, this is a gun which I have purchased, this is a receipt I got, this is a number which has been given to the rifle, and for this rifle I need a license, therefore provide me a license. There will be an application to the effect will be submitted to the Commissioner of Police, Chennai. This application will be taken out. Then the application will be taken out and will be brought on record, and it will be used against him, saying that you yourself has made admission, this rifle belongs to you. The rifle which was involved in the crime was made against, this was involved in the crime belongs to you, and you have to give me the explanation. What is the beauty is that two pullets or the bullet that emanated from the rifle also tallied with the unused pullets of the rifle. Unused pullets were recovered from Coombe River. These rifles were also recovered from the Coombe River, and both the things all will be tallied. And the rifle which had been fired, it will go to the one temple. It will enter into one temple and it will went out on the another temple. It will go and hit in the wall, a compound wall. A cavity will be created. Immediately after the occurrence, 2 o'clock the incident will happen. By about 4 o'clock, 5 o'clock the FIR will be filed. The moment the FIR has been filed, the inspector will come along with the mobile forensic science lab director. The director in the mobile forensic science lab will find out that cavity in the compound. There's a small cavity in the compound. The bullet after hitting at that this compound, after hitting the compound, it will burst like that and it will spread over something. 2-3 pieces of the copper and lead mixed bullet. This bullet was recovered by one of the colonel called by name Shaker, and he will come and give it to the inspector of police. The inspector of police will send it to the forensic science lab, and to tally that unused bullet that was recovered in the Coombe River, which he has thrown, which was fall under section 27 of the Evidence Act, he will thrown and it will be subsequently recovered on his information being given, the accused information that's having been given. And this unused bullet will tally with the used bullets. The quality, quantity, all this contents, everything will be same. So this is the 27. We can make use of it for 27. Before that, I wanted to say there is a cavity that's been created, you see. That cavity was figured in the observation magazine. So this cavity comes under section 7. That's what the finest judgment that's been written here in High Court. It's a very finest judgment. It's the cavity that's been created is relevant, and it will fall into section occasion, cause, effect. This is the effect of the firing that has happened, and because of this firing, this cavity has happened. Almost the boy's height and the firing height will be almost same, about falling short of about 2 or 3 inches like this for this gap. For 2 inches or something different lower than. So exactly it will tally with if the boy is going to stand here in the compound, exactly it will tally with this. The height of this cavity will tally with this temple, left temple or right temple, whatever it is. So this how that this whatever happened is matched with the occurrence, how it is connected to the accused. All these things, each and every circumstances, each and every piece of evidence that is collected by the court, all these things are connected, and it is connected to the accused, whether this things connects the accused to the crime or not. This is how it has to be seen as far as this program in the Evidence Act is concerned. Now I have narrated the section 21 of the Evidence Act. 22 and 23 is also something relevant to civil case. The oral admission witness to the contents of the document is very easy to read and easy to understand. You can skip over it. And 22A is also when the electronic contents of the electronic records are not relevant. It is relevant when the electronic record, genuinity of the electronic record is going to be disputed. It's under question. The genuinity itself is questioned, then the oral contents to the electronic records could be admitted before the court of law. That's what the 22A says. And 22.3 says that admission in civil cases, the mandatorily in admission in civil cases, if there is a clause in the admission that it should not be used as an evidence, then it is inadmissible. You cannot, it's irrelevant, it cannot be inadmissible, it has to be thrown out. So the admission should be free of any agreement that it should not be used as evidence before the court of law. This is called the section 23. Up to 23 I have covered clear. Okay. Now coming to the 24, which is very commonly used in all criminal cases. That's called the extrajudicial confession. What 24 says? 24 says about the confession. The confession should not be, what it says is, it is a negative sentence. The confession caused by inducement, threat, promise, when irrelevant in the criminal proceedings. If the confession does not have confession minus inducement, minus threat, minus promise, then it is relevant. That's what it means. When it goes irrelevant, confession goes irrelevant in the case of threat, in the case of promise, in the case of any inducement by anybody else upon the accused. If such on inducement, such on threat, such on promise that the confession has been confession has been obtained from the accused, then that is not admissible at all. Suppose if the confession has been extracted, that giving some advantage or the confession has been given by the accused to escape from the clutches of the temporal punishment, temporal nature, any treatment of temporal nature, the third grade treatment of the police. So in such cases also it becomes irrelevant. It goes in the threat promise inducement, which is coming under the threat promise inducement. What is the corollary for it? What it says out of this inducement, threat promise inducement? So the section aims that the confession which is given should be voluntary. Confession should be a voluntary confession that should be given. If it is going to be voluntary, if it is given without any threat promise or inducement, then the confession could be taken on record. It could be relied upon on the basis of which the confession could be recorded if it inspires the confidence of the court. That's what the section 27 says. 24. That's what section 24 says. 24 mandates, 24 ensures there is an absolute voluntariness in giving the confession. There should not be any influence, there should not be any threat, or should not be any promise at all by anybody else, including the police officers. So therefore, in order to save the accused from the compulsion of giving confession, this clause has been introduced. If you take the background of this section 27, you will have to go to Constitution of India. Then the Constitution of India, Article 23 of the Constitution of India, it says about no one can be compelled to be a witness against himself. No one can be compelled to be a witness against himself. See, this is stipulated in the Article 23 of the Constitution of India. So, in accordance with the 23 of the Constitution of India, this section 24 gives a protection to the accused that if the confession has been cast, if the confession has been extracted by means of threat, promise, inducement, then it becomes irrelevant to the proceedings. Then comes the confession given to the police officer. Confession to the police officer completely thrown out. It is not, shall not be proved at all. No confession given to the police officer, made to the police officer, shall be proved as against a person accused of any offence. No confession made to the police officer shall be proved. Fixed. There ends the matter. If the confession is given to the police officer, this 24 gives two extensions. One is 25. Confession 24 says it should be voluntarily. Confession 25 says that should not be given to the police officer. Even if it given to the police officer, it should not be proved at all. Confession should not be proved. It shall not be permitted to be proved. It's not irrelevant. It's the question of relevancy doesn't come here. The question of admissibility doesn't come here. It goes beyond it. It shall not be proved before the court. Don't bring it to the court. Don't bring it, attach it in the charge sheet at all. Take it away. That's it. It shall not be proved as against a person. So 25 is an extension for 24. Like that, 26 is also an extension for 25. 26 is also an extension for 24. There are two extensions. We can take it like this. 25 is extension for 24. Likewise, 26 is also extension for 24. Or you can take that it's an exemption for 25. Extension for 25. 25 says, no confession given to the police officer shall be proved. Here, no confession made to any person while in the custody of the police officer. That's included here. While in the custody of the police officer, 26 says, while in the custody of the police officer, the immediate presence of the magistrate is required. What is stated? The immediate presence of the magistrate is required. That 26 says. So therefore, for the purpose of 26, you will have to go to CRPC. What CRPC mandates? Here, CRPC gives procedure under section 164 of the Evidence Act for giving a confession. The magistrates having certain duties from the section 26 of the Evidence Act. So under section 26 of the Evidence Act, if the magistrate wants to record a confession, the magistrate has to abide by the procedure established in section 164 of the Evidence Act, 164 of the Criminal Procedure Code. Here, what 164 says? 164 says the police will send the man to give a confession, or he will voluntarily come to the confession. First, you will have to ensure whether there is a voluntariness or not. Under section 20, comply with the section 24 or not. 24, voluntariness not been expressly defined. Expressly, it has not been stated. But threat, promise, inducement, if you take it away, if a statement is given not under the threat, if a statement is given not under the promise, if the statement is given not under the promise, threat, inducement, not under inducement, it is a voluntary statement. No one else compelled you. No one has compelled you. No compulsion for you to give that. So therefore the voluntariness comes. So therefore, if the voluntariness comes, therefore he has to ensure it in the 164 of the Evidence Act, CRPC. In the 164 of the CRPC, magistrate, once the witness comes, not witness, that accused comes for the purpose of giving a confession, he has to say, he is bound and duty to, magistrate is of the bound and duty to say that you are not bound to give the confession. You are not bound to give the confession. Your confession may be used against you. It may be used against an evidence against you to convict you. So it is against Constitution under Article 23, Clause 3 of the 23. Therefore, you are not bound to give this confession. Therefore, you can take rest. You say that he will also, if even after saying that you retire, if the accused wants to give the confession, the magistrate will give a relaxation period of 24 hours. You go, think over, take rest, think over, and come back, relax, come back tomorrow, we will decide about it. If you want to give a confession, I will record the confession. Then the next day, if the accused comes, he will record the confession and saying that I explained all these things to him. He is not bound over by the confession. He is, if he gives a confession, it will be used to evidence against him. And also he has to record the confession, and he has to give a footnote at the bottom of the confession saying that I clearly explained all the statutory warnings and other things, and even then he gave confession. I believe that confession is voluntarily. This is a key word that has to be endorsed in the paragraph. It's that I believe that it is a voluntary. In 1964, instead of I believe that it is a voluntary, one of the magistrates has written that I hope it is voluntarily. It came up to Supreme Court in Chandran versus State. You can take it from the Google. You can take it from the IndianQanun.com. You can take that Chandran versus State. If you take the magistrate, instead of saying that I believe that it is voluntary, he has written that I hope that it is voluntary, which was strongly deprecated by the Supreme Court, saying that this is not the word that has to be written. So therefore, the voluntariness has not been ensured, and the benefit of doubt has been given to the accused. So this is on one word which changed. If the magistrate would have used believe that it's voluntarily, the magistrate would have used that it is believe that it is voluntarily, he would have got punished. Instead of believe, I believe that it is voluntarily, the magistrate has used a sentence, I hope that it is voluntarily. There's a hope and believe is a difference. I hope it is voluntarily, he got acquitted in the Supreme Court. This is Chandran versus State. This Chandran versus State is extracted in Dr. Bhaskar kidnapping case, very popular case in Dindigul. That case is cast titled as Ravi Kumar versus State. It's not available, but it's available only in the High Court library. You can take it and read it. Dr. Bhaskar's case was he will be kidnapped just opposite to 9 people will kidnap in a Tata Sumo, just opposite to his house. His shoes and other belongings, bags and other things. He will go to the Cosmopolitan Club in the morning, and just crossing the road, the car will come and stop. He's a very big billionaire, I think, having some resort in Kodaikanal and all. A aged man, about 65 to 70 years. Some 9 people came, and 2 or 3 got down, and he will be taken into the car, and he will be kidnapped. And the watchman will see that this man, he has been kidnapped by somebody else. His bag is lying there. Immediately, wife will come and see. The son will come and see, and the police information will go. The people will lock him somewhere else for about 8 days. The body will be recovered in Aliyar Dam after 7 or 8 days. Only one will come forward for giving the voluntary confession, that is A9 there. A9 mostly will say that I am an engineering graduate. I am not inclined to participate in this occurrence, but all the other people made me to participate on gunpoint. I wanted to go for my interview for my job, but these people did not permit me, though. So therefore, it was not taken as a confession. It was taken as an exculpatory statement, which does not pinpoint any guilt on his part. It's saying that it's exculpatory. I do not want to participate. I wanted to escape from there, but yet on gunpoint I was told I did not participate. I asked them to leave this man, very old man. So therefore they did not leave, and ultimately he died because of starvation or because of throwing in the river, whatever it is. And A9 will give statement. Of the A9 statement, whether all the persons could be convicted, A9 is a exculpatory statement. A9 was not at all taken as the confession statement. So it's totally an exculpatory statement. Therefore, they said that I cannot be taken, and therefore it was the A9 along with A4, A5, A7, A8 were acquitted. A1, A2, A3, some A3, A4 were convicted in that case, I think. This is for the purpose of I am saying that confession to the police officer. Up to 26 I have completed. I think that time is up. Madam is also on the line. Therefore, better I think that I can stop my course of lecture. And thank you so much for the opportunity that's been granted. I hope that we will be meeting again someday in the future. And for the rest of the
thank you, sir. It was really nice, and it shows your passion towards the subject and also in-depth knowledge. And it was almost literally a song. It was going on. We didn't want to interrupt. But since the closing time has come in, we will meet sometime this week itself, sir. If you can give a date, I will try to contact you over phone and get a date.
Sure.
It was really nice, sir. Thank you so much.
Sure.
After the sessions of all the provisions being over, we will have the Q&A session, sir.
Yeah, sure.
And if there is any question, I'll just connect the participant to you.
Sure, madam. Sure.
Okay, sir. Can we close it for today, sir? With your permission?
Sure. Thank you so much. Thank you so much for that.
Thank you. On behalf of Legal Elite and all the participants who have joined in today, nearly 200 participants initially had joined in, and all of you would have really enriched your knowledge, and It's really a pleasure inviting you time and again, sir. Thank you so much. It was really excellent. So this week, one more date, I will see to the schedule and get connected with you, sir, so that we'll fix one more date. Thank you all. Thank you so much. Tomorrow morning, we have 11:15. We have Constitution by Karthikeyan sir, the special government leader, and evening we have Mr. Pratap continuing Indian Contracts Act. So tomorrow also two sessions, one in the morning and one in the evening. So you have to get connected to that. I'll be posting it in all